today. My name's Caroline Carver and I'm the Principal Consultant at Three Black Cats. So today we're going to talk about the information life cycle. If you've got any questions as you go along, feel free to pop them in the Q&A and we'll try and answer them as we go along or at the end of the session. We will be recording today's session, so if you miss any bits, etc., we'll be publishing them on our website. So before we can start and talk about the information life cycle, we need to talk about what personal information is, because although the information life cycle is useful for any sort of information, today we're just going to talk about personal and how the Privacy Act applies in New Zealand. So personal information is defined as anything that tells us something about a specific individual. Now, we don't need to be able to name that individual, but we do need to be able to identify them. So it might be all information relating to the person who looks like this, or it might be all information relating to someone who lives at this address, or has this IP address for their computer, or this MAC address for their phone or device, particularly when we're talking about things like marketing, or who has this social media handle even is becoming more so important. But we need to know it's all about a person. And we're saying the Privacy Act kicks out when you are deceased. They have to be a living person. However, that said, be very careful thinking the Privacy Act doesn't apply at that point, because most living people have relatives, etc., whose information you may be able to infer as well. So what kind of information is personal information? So it can be things about their external body. So it could be what they look like, so the shape of my face, the colour of my hair. Could be things about my ethnicity, could be about how I behave. So am I a particular person who uses a lot of hand gestures? Am I quite reclusive? And that's all about me, right? So about how I live my life, how I behave. Maybe I'm a person who doesn't want to make eye contact. It could be identifying information, so things like copies of passports, driver's licenses. And those, by the way, are some of the most sensitive information, because all of this category I can't change. Could be something about my sexual persuasion, so maybe I'm part of the rainbow community. It could be something about my medical conditions, and again, can be highly sensitive. So what diseases do I have? What tests am I undergoing for other things, etc. Some harder ones. It could be about my internal thoughts. So what do I like? So I'm myself a particular fan of donkeys and horses, and we have a lot on our farm here. It could be what I think about somebody, what I think about your company or your products. Could be things about how I like to authenticate, or my preferences. So do I want your marketing emails or do I not? Do I want to opt in to have you send me an e-receipt or not? That's all about me and how I want to live my life. Can be social things, so criminal records, again, highly sensitive, but it can be things about my family, what I post on social media, how I want to communicate with your organisation, my professional work, so where have I worked, how have I worked, what my performance at work is like, etc. It could be things about my devices. So my computer, what apps do I have installed on my device, particularly my cell phone? Who do I have contact with? So who did I spend my weekend with? Or where did I go at the weekend? Okay. And then it might be financial, something about how much money I owe, what I bought with my money, how I choose to spend my income or not spend it, how many houses, how many dogs, those sort of things. So as you can see, a lot of information could be personal, and it is all very context-based as to what is personal and what is not. And that's really important to remember. There is not a black and white rule about it. So if we take a use case, for example, My power usage at my house, if I live alone, will be personal information because I'm the only person living there. My actions solely run up my power bill. If I want to leave all the lights on, that is an action I took. I ran my own power bill up. If I live here with 4 other people, it most probably isn't personal because you can't say that my actions as an individual is one of those 4. Which part of that power bill was me? Unless you have some other information, like the other 3 people don't work at home during the day. Okay, now some bits of it have become personal. So it is very contextual based about what it is. So, information privacy principles. So the Privacy Act has 13 principles and it now had an addition in 2020 when the Privacy Act changed. And we're going to talk through each of these in turn, but we're going to talk through them in groups rather than principles 1 to 13. But on the slides, we have got which principles it relates to. And the reason we're going to talk through them in groups is because it's a lot easier to understand how they work together if we think about how information flows through our organization and what bits take our requirements at what stage. So, for example, our organization will collect information to start our process. So that might be an individual fills in a form, or they call us, or they engage with one of our social media ads, or maybe somebody refers them to our organization. So they might might be a mortgage broker, puts a referral through to us and says, hey, contact this person, they'd like a mortgage with you. It might also be that we created information about them. So by that, I mean, we could see they were browsing on our website and their actions were creating a track of them that we then augmented with some other information. Whenever we collect information, we have to provide notice. So we have to tell people what we're doing. I'm going to talk a lot more about that later on. We then have this information now in our organization and we will use it for a series of things, hopefully what we told people for. We then need to secure it and make sure that it doesn't disappear or get used incorrectly. We have to retain it for a period. In a lot of cases, that might be set by legislation. So, for example, we need to keep our tax records for 7 years after the transaction. We might disclose it to some people. So common ones is we might get a request to give it to law enforcement. So police might ask us for a copy, or we might share it with a parent company or another company in a similar group for our brands. Or we might actually give it to the individual themselves, or maybe someone who's authorized on the account. And when we're finally done, we need to destroy it. Now, our obligations under the Privacy Act don't finish until we destroy it. Okay. And by the way, this includes if we are using vendors. So if, for example, we use Microsoft to host our information for us, they are an extension of us. So they are part of the royal we. And whatever they do with the personal information they're holding for you on your behalf is deemed to be done by your organization. So if we destroy all our copies, but Microsoft has still kept their copy, then we still ultimately have a copy of it. Okay. And we'll talk about how that applies a bit more as we go along. So let's start with talking about how we collect information. So we've got 4 privacy principles that this applies to, 1, 2, 4, and 13. So first and foremost, principle 1 says that we can only collect information that we actually need. Now this, when we talk about need, that is a need today. That is not, might get a need in 2 years' time. We might want it to promote a new product or add something to this current product in 2 years' time, maybe somewhat. That is not a need. That is a want, not a need. So we need to think about what we actually need. So the most commonly over-collected information, so things we collected without a need, are gender and date of birth, okay? Most organizations do not treat you any differently, whether you are male, female, or another choice. And therefore, we don't actually need to know your gender. We're not going to send you pink marketing if you're female and blue marketing if you're male. It's likely it's going to cause great offense. So we need to think about, why are we asking their gender? Are we actually going to treat them differently? And actually, would there be a better data point that we maybe should collect if we're going to treat them differently? Now, some organisations will need to collect gender. Think about health conditions with a particular prevalence to certain genders. Absolutely. Life insurance is another one. We really do need to know your gender. It's used for calculations. But if we can't actually explain what we're going to do with the piece of information, it's a fairly good indication we shouldn't have it. Okay, so we should be able to point at it and say, in my business process, I'm going to use that for X. Another common one we see is date of birth. The common use case I get told why we need date of birth is either it's a birthday special, or we need to know their age. Perfect. So if it's a birthday special, we most probably don't celebrate your 39th birthday. We celebrate your birthday. So we need your day of birth and your month of birth. We don't need to know how old you are. If it is about your age, most probably we can just get away with having your month and your year, or even just your year potentially, or an age bracket. Depends what you're going to do with it afterwards. Okay, so that's principle 1. Principle 2 says we need to only collect stuff from the individual concerned wherever possible. And the reason for this is it's likely to be more accurate if you get the information from the person concerned. So, for example, if you ask my husband about my car driving history, he will have a version of the truth. It may not be the full truth. So if I was your car insurer, I would most probably want to get the truth from myself first and foremost. However, there are times when we need to get information from someone else. So maybe they are the authoritative source. So if we think about immigration records, we might ask our employer, hey, do you have the rights to work here? They will give you an answer. However, we most probably want to check that as well. So we will go through Visa View and confirm it and collect information from MB to confirm their status. Equally, we might be collecting things like their credit rating from the credit bureau, and that is also okay. But first and foremost, we do need to think about, should we be collecting that way, and do we have good reason for it? And that will become important when we talk a bit more about notice shortly. When we collect up our information, Principle 4 says we need to be balanced and not overly intrusive about how we collect it, and we have to be legal. So that means if we are scraping off the internet all the personal information we know about somebody, and that is a breach of LinkedIn's terms and conditions and Facebook's terms and conditions, you haven't collected it lawfully, therefore you shouldn't have it. And you shouldn't then proceed to use it in ways. We also need to collect it in the least intrusive method possible. So listening behind bus stops, unless you are most probably a surveillance agency, law enforcement one, most probably not okay. Particularly this comes to play when we talk about CCTV, for example. How intrusive is CCTV? Where is it positioned? Is it just over the front door, or is it in the bathrooms of your organisation? Okay, one's really intrusive compared to the other. Particularly when we consider minors and vulnerable individuals, we need to give real care for how we collect that information and whether we can do that in another way. And that was added to the Privacy Act back in 2020, that requirement. And last but not least, in Principle 13 says that if we are collecting unique identifiers, So that might be your driver's license number or passport number. Then we should only collect them for the purpose for which they were allocated. And we can't use another organisation's unique identifier as our own. So, for example, we can collect someone's driver's license number if we need to know that they have a driver's license. Yep, that's valid. But we shouldn't then search our records to see which hire car you have taken by searching on the driver's license number. That is not okay. Okay. As a general rule of thumb, collecting anyone else's unique identifiers other than their IRD number can quite often cause issues. So you need to take particular care where you are collecting those identifiers. So what do we need to tell people? So when we collect, or ideally before we collect people's information, we need to tell people what we're up to. So we need to give them what's called a privacy statement. So we're saying that's not to be confused with a privacy policy, which is your internal document about how you manage privacy in your organization. Can be confusing because other countries do call it different things. But the privacy statement or privacy notice is what we legally got to give. Okay, so this is something we give to people, and it says who's collecting your information, why are we collecting it, so what are we going to do with it, why do we need it, who are we going to share it with, and also tells people what their rights are and whether it's compulsory to provide the information. So it usually reads something like, we're collecting your information to, if it's an online shop, to deliver the purchases you asked for so that you can track where your goods are, get a warranty claim, and communicate with us if you don't, if you can't find your goods, they haven't arrived. Might also say something about, and we use it to detect fraud on our online website. That might also be a valid use. We do need to think about all the ways we collect information and use it as well. Particular care thinking about, are we using it in things like test environments, as that will need to be declared as well. So this privacy statement we've written quite often is on our website. It might be linked into our forms. So say it's an online form where I'm going to fill some information in. It might be linked off the bottom of that form. It says, if you want to read about how we use your personal information, it's here in our privacy statement. It might be linked in the bottom of your forms, or it might be included in the bottom of your forms if you have paper forms. When you are doing things like contact centres, however, so when someone's calling up and you're going to record their call, it is not usually very practical for you to read to someone the whole privacy statement for your organisation. So what we would do in that circumstance is explain the pertinent points that relate to what's going on at this time and then reference it. So it might be, we are recording your call today for training and quality purposes. For further information about how we manage your privacy, our privacy statement is on the website. Okay, so make sure it's practical for what you are doing. Now, at the moment, we only need to give a privacy statement to individuals where we collect the information directly from them about them. Okay, so we're talking earlier about my husband. If he provides his information for car insurance, we need to give him a privacy statement. If he provides my information, at the moment, we don't need to give myself a privacy statement. However, come May next year, if you are collecting information about someone who isn't the person who provided it, you will need to provide a privacy statement from May. Okay, so that means that if my husband provides my information as well as his own, you're going to have to find a way of getting that privacy statement to myself. Okay, so that new principle has been called Principle 3A, and there is a lot of guidance on the Privacy Commissioner's website about what that change means to your organisation and how to navigate some of the exceptions. and best practice about it. We're saying that change is quite significant, so do not wait till May for it. You will not be done in time. Even don't wait for Christmas. Some organisations won't be ready in time. If you want it, we also have some other videos solely on that topic on our website under Lunch and Learn if you need more information. So we've now got this information in our organisation and we are responsible for securing it. Now, earlier I talked about the royal we. So not only if it's in your organisation's possession, but if a vendor has it and they have it solely because you asked them to do something with it, in other words, deliver a service to you, then you are responsible for it being secured there as well. So we talked earlier about things like Microsoft, but it might also be a recruitment agent or a marketing agency or someone who's doing analytics for you, or even someone who's just doing a survey for you. So we need to make sure that that information is held securely. Now, what security controls you need will very much depend on the information you hold. Okay, so the information that about your health conditions, you would expect to be very, very well secured. It's hugely sensitive. We don't want anyone else to get hold of it. The information about, I know, where I went on Saturday, maybe less sensitive. What I bought at a shop, maybe a bit less sensitive than my health records. But you need to make that risk-based decision about what controls are appropriate. Now, one worth calling out, the Privacy Commissioner has indicated that two-factor authentication, so that's that thing that pops up and says on your phone and says, was this really you who just logged in? Or here is your magic number. Is expected for organisations, for any organisation who has personal information. So definitely one to watch for. And that's become industry standard now on any of your apps. So we're protecting our information from people stealing it. So that might be a hacker who's coming to break into our organisation and take away all our personal information. But more importantly, it's also about our own staff. So it's making sure that our internal staff don't have access to more information than they need. So not every staff member needs to have access to everything we hold. So if we think I'm the person who works in your mail room, whose sole job is to deliver mail to the internal staff, most probably they don't need access to your customer records, nothing to do with their job. So we need to make sure we've secured it so they don't have access. And we'll talk more about this later in the week. But one of the key privacy breaches we see is caused by what's called staff browsing or unauthorized access. So that's when someone shouldn't have been there and went there on a bit of a mission to look up something they shouldn't have been. So when we think about our vendors here, if we are going to onboard a new vendor, one of the key things we need to check is, are we happy with what security they're going to provide in terms of the information? I'm going to talk later in the week about breaches, but that will come out in terms of if there is a breach at your vendor, you are still responsible for it. It's your personal information for your organisation. Therefore, the responsibility lies with you guys for that breach and how it is managed. So you need to be really sure when you onboard that third party, that vendor, that you're happy with the security options they are offering for you. So how can we use the information? So we go back to what did we tell people in our privacy statement? So first and foremost, we can only use it for the reasons we told people. Okay. So that refers back to what did you write in your privacy statement about the uses we were going to do. Now, we need to be very careful of that in terms of complaints. And the reason I say that is the privacy statement, although you make it available, is usually not well read. in your organization or by your customers. They have to maybe click to agree to it. Maybe they don't even need to agree to it. It's not compulsory they do. Therefore, there'll be a whole bunch you've never read it. So if you are going to do something that is unexpected to a regular person who engages with your organization, you need to really call it out to people before you do it. Okay. So common one we're seeing more and more at the moment. I'm going to use your personal information to train the AI in my organization. Now, a lot of people will be like, yeah, I'm okay with that. And other people are like, hell no, don't like that idea at all. So maybe for that one, we should give people the choice of whether they want it to happen or not. And not just bury in our privacy statement somewhere, hey, one of the uses for using your personal information is to train our AI. No choice on the matter. Okay, that will lead to complaints from people. So when we think about using it, we need to think about all users. So when I talk about that, we quite often see privacy issues occur due to product development, so testing and developer teams using copies of production personal information in non-production environments. By that, I mean they've copied all your production data into their test environment, and they're now happily testing away on real life customers. In that case, it is not good practice, first and foremost, to test on production customers, because your obligations for protecting that personal information, how it's managed, are carried over to that environment. So we need to be very careful about, were we clear? Are they actually using it in accordance with what we said? And how are we going to publish it, for example? Now, if we realise after the fact, after we've collected it, that the personal information, we need to use it for another reason, it is not enough to simply change the privacy statement to include our other reason at the time. The privacy statement that applies is the one they were given at the time of collection or that you have notified since. So we need to think about, have we told them it would change? So if we want to use it for a new purpose, so say we do want to train our AI on it and we haven't previously, then we need to, usually in most cases, seek the person's permission for that. Okay, so we need to actually go out to these people and say, are you okay with this? Now, it might be that the only choice we give them is, and if you're not okay, your choice is to leave our organisation. Okay, that's a bit brutal, but in some places that might be appropriate to your business. In other places where that is not appropriate, we might need to think about, okay, how do we ring fence these customers who are not okay with that new use? Now, there are a few other exceptions about how we can use personal information. So a couple of examples. We can use it for statistical and research purposes where the person can't be identified in terms of printed output. So we can usually run quite a lot of metrics and analysis if we want without it needing to be in the privacy statement. Good practice to put it in anyway, but we could do it. We can also use it if it is aligned with one of the purposes for which we collect in the first place. So it might be that we said, we will collect your information using an online form. And now we're like, oh, oops, we forgot to mention the paper form. It's close enough that people's expectations are it's similar enough. Going forward, we might want to remove the word online, just say through a form. So who can we share personal information with? So first and foremost, before we do any sharing, and actually we'll just jump back, before we do any use as well, we need to ensure that the information we hold about the person is accurate. So when we're using it, for example, if we think about we're going to mail out to all of our customer list, if our last addresses for this customer are 4 or 5 years old, maybe older, the chance of getting gone not at this address back from those customers, if you've not had an ongoing relationship with them, is really high. So we maybe need to think about, A, what are we sending in terms of, is it going to be highly sensitive if the wrong person opens it? But also, is it actually a waste of our money? In particular for use, though, we want to think about, is it accurate, particularly if we're going to take things like fraud actions. We're going to stop you shopping with us because we believe you've been doing fraud. Okay, cool. That's legit. If I've actually been doing fraud, if you've misflagged my account, that's not okay. Okay, so who do we share with? So we can share with anyone where we have told the people that it's going to happen and it relates to the purposes for which we collected it. So if we think about my online shop, I may well have told people I'm going to share it with New Zealand Post so that they can deliver the product to you. Well, that's legit. You bought it, you wanted it shipped. I'm going to have to tell the shipping people where you want it shipped to. Don't need to tell them what's in the parcel potentially, but I need to at least give them your contact details if I want it tracked, and they will then send you the nice emails saying, hey, it's on its way, it's been delivered, etc. If we think about parent organizations, so if you're a group of companies, you might have told people we're going to share it within our group of companies because we have a shared loyalty scheme. Again, legit. We might need to share it because the law requires us to, right? So if you take this action, we will have to share your information so that we can do anti-money laundering checks, or we will share with the credit bureau to check your credit rating before we give you a credit card, because we need to do that. We're not going to lend you money without having it done. Now, those are the common ones. Those usually, as long as your behavior is not unexpected and out of the norm, those usually don't cause as many issues. Where it does cause issues is if you are going to share it in ways that people don't expect. So if we think about going to a conference, buried in their privacy statement, it said, we're going to share your email address you bought your ticket with every person every vendor who came to this conference who was in the vendor thing and vendor hall. Most people are like, oh, yeah, I expected, I don't want it, but I expected it. All good. However, if you are going to share it with every attendee at the conference, and now you're suddenly getting all these random emails from people you don't know, that is not okay. People will not be happy. So we need to think about, what is that social norm? If you want to give people the option to opt in to sharing it with every attendee, fine, but make it a choice people have and make it really clear to people if that's going to happen. So other reasons we might want to share. So we have the ability to share with an organization who can take action if we believe there is a risk to public health or safety. Okay, so this means that if we believe somebody is walking around with a gun, trying to kill people, then absolutely, and we've got them on our CCTV, then absolutely you can share that footage with an organisation who can do something. So that's not your store next door. That is the police. That is the armed defenders squad. That might be mall security if you're in a mall. Okay. Equally, it might be in cases where we need to share. So if we think about a lost person, for example, and we are worried about what has happened to them, we are able to share, well, actually, we last saw them log in at 2 o'clock and they were at this location. Maybe if we're tracking their location, maybe we're a cell phone provider. We can say, and their cell phone was at this location. Okay, again, to an organisation who can actually do something. So again, usually the police. Other organisations you might need to share with under that exception, quite often some of the health agencies, WorkSafe, ACC, those sort of people. Okay. We might need to share information to enforce the law. So we have a couple of scenarios that this comes up in. we have a court order. It says police want to know this, or customs or immigration. In that case, we have no choice. They have a more superior piece of legislation that says do it. It's called court order. Our choice is to get on and do it. That said, we have to share the least information that we can in order to meet the requirements of that order. So if they ask for a name and a photo, that is all we are sharing. We don't need to share, and they were here on Tuesday and they did this and they did that. It's literally name, photo. Now, we can voluntarily share without a court order if we believe it's necessary. So the common one is, please come to us, quite often for CCTV footage. They don't want to go get a court order, but they come to us and say, look, there was an assault in your car park last night. We think you've got it on CCTV. It was about this time. Can you check and see if you've got it? Now, if your organisation has it on CCTV and you are comfortable that you think a crime has been committed, so it's not just someone just randomly wandering, there is actually, you're like, oh yeah, I can see a punch up, then you can absolutely share that. You can also share information where it has been anonymized. So when we say anonymized, it needs to be in a state where nobody can re-identify the person easily. So it doesn't mean just removing their name. That means actually taking some steps. And maybe we've removed all the people who are very young in our age bracket or very old. We've made sure we have removed their house number and their email address as well, because that's all quite easy to re-identify someone. So we could, for example, share, if I was the rubbish collection company for the wheelie bins in my area, I could share information like there are 10 people in this street who subscribe and have their wheelie bin empty weekly, and there are 11 who get it done monthly. Yep, that's not said anything about anyone in that street. That is more about a population. So that's okay. Now, there is an extra piece to the Privacy Act that was added in 2020, and that is about sharing information overseas. So if we're going to give personal information to an organisation who's not in New Zealand, we have obligations to make sure that it is protected in a similar way to what a New Zealand organisation would have to do. So in order to do that, we have to either be sure that they're covered by the New Zealand Privacy Act, which a lot of organisations, even if they're based in the US, might be covered by the New Zealand Privacy Act. So Facebook, for example, is a common one. It is covered. But if we are going to give it to, for example, Australian police, we need to only give it where we have surety of their levels of privacy. Now, the Privacy Act allows for a list of safe countries and safe regimes called a whitelist to be created by the Ministry of Justice, which is countries where Government Inc. has said it is okay to share with those organisations in those countries. Now, currently, before we all celebrate and think, yes, great, the list has nobody on it. Okay, so it is a white list of 0. So we can't rely on that at the moment. So we need to then think about what we need to do in order to share. So the Privacy Commissioner's website has some really good model clauses that we can pop in the back of an agreement where we're going to share information overseas to ensure that we have the same protections that we have in New Zealand when it goes overseas. So that's there and available for you. And all of these disclosures, it's worth saying, in all cases, we need to make sure it's accurate. And we also need to make sure that we disclose the bare minimum we can to achieve the outcome of it. Okay. The most common disclosure we see, by the way, is off your websites. So your organisation has a website. It is running a whole bunch of marketing and tracking technologies. So it's got the Facebook pixel, the TikTok, the LinkedIn, etc. As a result of all of those, they end with you disclosing information to those third parties for their own purposes. So if you run, for example, the free version of Google Analytics to see who's visited your website, as a result of that, if it's the free version, you have gifted or disclosed to Google the details of the person who visited, their device details, and the fact they were on your website. Okay, so that's all personal, it's about them. And then Google are able to use that for their own purposes, otherwise known as selling it for ads. And that's how come your Facebook feed, etc., your search history, all suddenly become filled with ads for things you were looking at on the internet. That's how it works. So we've now got all this information. The principle we are worst at in New Zealand of all things. Once we are finished with it, we need to destroy it. Now, we need to know, therefore, when are we done with it? Okay, so some organisations will have a retention and disposal schedule, particularly government entities are required to have one under the Public Records Act. And this will say, for example, we need to keep employees' CVs for X period of time after they apply for a job. And it might say, and if they're the chief executive, we need to keep it for 10 years. And if it's a normal role, we need to keep it for 3 months. Once that period is passed, the Privacy Act then requires that we destroy it when we no longer need it. So if we think about an organisation that doesn't have a retention and disposal schedule, and I've applied for a job, I wasn't very good, so I didn't get the job. There is no requirement, therefore, for that organisation to have kept a copy of my CV. Maybe they need to keep it for 30 days in case the best person for the job turned them down and they want to recontact me because actually I wasn't so bad after all. But if I was completely inappropriate and they're never going to come back to me, they do not need to keep a copy of my CV. Now, you will be amazed how many of your organisations, hiring managers, have whole folders of CVs for people that they are never going to hire. It's a really prime example of where we should have destroyed it. Equally, if you are keeping customer records, if the customer has left, I know, so if we go back to, I know telco, right? There might be legislation that says they need to keep your records for a certain while, your call records, and particularly your bills. So maybe we need to keep your billing for 7 years for tax purposes. But after that period, if I'm no longer a customer, then we should not have my record at all. Okay, so we, at that point, need to have deleted it for me. And the reason we want to delete stuff, as well as it being good practice, is there's nothing more embarrassing than having a privacy breach, losing all your records, and having to write to this customer to say, hey, dear ex-customer of 10 years ago, oopsie, lost your highly sensitive personal information that we should never have had in the first place because you haven't been with us for ages. If you're a commercial organisation, they ain't coming back anytime soon. So just consider that in terms of how it behaves. The common argument is I'm keeping it because they might come back. Okay, so 10 years down the track, if I come back to your organisation, the likelihood is I have a different email address. Maybe I have a different phone number. Most probably have moved house at least once, if not many times in that period. So actually the information you held on to is likely really incorrect anyway. So it's of no value to you to still have it. And I spoke earlier about being responsible for your vendors. Destruction also applies to your vendors as well. Now, a lot of your vendor contracts will say on cancellation of this contract, we will delete all your information. A couple of things. A, you're responsible for making sure it happens, but also, do you want them to keep hold of all your information until your contract ends? Or actually, would you like them to delete it beforehand? So if we think about maybe they're doing call recordings for you, and they've been with you 20 years. We don't need 20 years worth of call recordings. Likelihood is we're only going to play them back in the last 30 days, usually. So therefore, we should have deleted them after 30 days. If we're never going to use them, we shouldn't keep them for that rainy day. Okay. Last but not least, principles 6 and 7. And we're going to have more of a conversation about this on Wednesday. So principles 6 and 7 allow individuals to have rights to their information. So they are able to ask you for a copy of everything you hold about them. So that might be details of all the orders I've placed, emails I sent. Maybe I want a call recording. Actually, I do want that picture of the CCTV of me sitting on the train or bus because I want it. No, you can charge for that privilege if you are a non-government entity. Government generally can't charge, but there are a few exceptions that we'll talk much more about that on Wednesday. But yeah, they are entitled. Everyone is entitled to know what you hold about them. And that's to build transparency. The other piece is that once they have got a copy of it, if they want to have it corrected or they just want to have it corrected without having a copy, they are entitled to ask for a correction. So the most common correction we see that we maybe don't recognise as a correction on the process, I've moved, can you update my address? Actually, my phone number's changed. Got married, can you change my name? Got divorced, I want to change it back. Okay, they're all correction requests. Now, if we get one of these requests and we don't want to, or we don't believe we should correct their information, then we need to keep a correction, a notice of correction, a statement of correction, and the fact we haven't corrected it. So common one we occasionally see, you got my information from the credit bureau. It says I'm really bad with money and you should never lend me money. I've got an awful credit rating. Get a correction request. Please correct my credit rating on your documents. Yeah, I'm not gonna just take you on face value on this. I might go back and check your credit rating again. Okay, yeah, it's still awful. So in that case, I will keep a copy of your confirmation that your credit rating is still awful and a statement on file that says you asked us to correct it and we haven't done it because of the following reasons. We checked it and it's still correct as per the credit bureau. Okay. So we need to have, when we build and think about our systems, ways for us to be able to retrieve and find someone's information in our systems. Now, when we had paper records and everyone had one file, it was super easy. You pull their file out the credenza and you will be able to print a copy or photocopy every page for them. In the electronic age, the likelihood of all their information being in one place is really low. Okay, so I talked about a call recording system. Yep, but they've got records in there. Maybe they've got records in a payment system. They send emails to your contact center. Yep, there'll be some there. Maybe we've got them on a list for marketing, some there, etc. So it has become very disconnected around our organization, and the number of places we need to look for that person's information will be significantly higher. Perfect. So that's a whistle-stop tour of the privacy principles. I'm going to hand over and see if anyone has any questions.